You ever have one of those deals, a handshake agreement or even a signed paper that just goes sideways? Well, today we are diving deep into a classic case of exactly that. We're going to find out what happens when a contract, the very thing that's supposed to hold it all together, starts to crack. So our story kicks off with two simple things, a $200,000 house and a signed contract to build it. On one side, you've got Ben, the property owner. On the other, Carl, the contractor. Seems pretty straightforward, right?
But if it were that simple, we wouldn't be talking about it. Despite having everything in writing, what looked like a solid deal just completely fell apart. It all unraveled into a huge legal mess.
And that brings us to the big question for today. When things go wrong, what does the law really care about? The promises you made face-to-face or the words you actually put your signature on? Let's follow Ben's and Carl's story and see what we can figure out. All right, so here's the quick play-by-play. It all starts in March when the contract gets signed. Things get a little tricky in August with a bonus offer. By November, the work is done, but right after Thanksgiving, that's when the real trouble begins. Okay, let's zoom in on that written deal from March 1st. The terms couldn't be clearer. Ben is the owner, Carl is the contractor. Carl has to build the house for $200,000. He has to use solar panels from a specific brand, Sun Company, and it all needs to be done before Thanksgiving. And here's the kicker, the fine print says this document is the full statement of their agreement. Remember that part, it's going to be important. But, there's always a but. Here's the first twist. Before anyone signed anything, Ben told Carl why he had to use those specific solar panels. It wasn't about them being better or cheaper, nope. It was because Sun Company was owned by Ben's brother. He was trying to throw some business his family's way. A verbal agreement, but not in the written contract. And this is where that little clause in the fine print becomes so interesting. It's often called an integration clause, and its whole job is to stop this exact kind of confusion. It's basically the contract saying, hey, if we didn't write it down in here, it's not part of the deal, period. This leads us right to our first big legal idea, the parole evidence rule. It sounds super technical, I know, but the concept is actually pretty simple. Once you have a final written contract, courts generally won't let you bring in old verbal chats or promises to try and change what it says. The four corners of the page, that's what matters.
Let's jump ahead to August. The project's moving along, but a new promise, and this big number is about to show up and make everything a whole lot more complicated.
So by late summer, Ben's starting to get antsy. He's picturing an unfinished house for Thanksgiving and getting really nervous. So he goes to Carl and offers him an extra $25,000. Not to finish early, mind you, but just to assure completion by the original deadline. And Carl says, sure.
So what do you think? Is that verbal bonus offer a real, legally binding deal? Can you actually get paid extra for just promising to do the exact same thing you were already supposed to do?
Well, the law has a name for this situation. It's called the pre-existing duty rule. And it basically says that for a new deal to be legit, both people have to give something new. You can't just promise to do what you were already on the hook for. That's not a new bargain. Let's just walk through the logic here. Carl's original promise? Finish the house by Thanksgiving. His new promise? Finish the house by Thanksgiving. See? He didn't offer anything new. In legal terms, there's no new consideration being exchanged. And because of that, Ben's promise to pay that extra $25,000, it's just not enforceable in court. Oh, but the drama doesn't stop there. Just when you thought it couldn't get any messier, Carl hits a huge snag. He goes to order the solar panels, and guess what? Sun Company, the one and only supplier allowed by the contract, is totally out of stock. He's in a real bind. Now, Carl has a choice to make. To hit that Thanksgiving deadline, he makes a call. He installs solar panels from a different company. Now, to be clear, these panels are of the exact same grade and quality, so functionally, the house is just as good. But he has, technically and directly, violated the specific words written in the contract. And this brings us to another huge question in contract law. Does every single tiny detail in a contract have to be followed to the absolute letter? Is there any room for common sense when a small change doesn't really harm anyone? And the answer is yes, there's room. It's a concept called substantial performance. The law gets that in the real world, things aren't always perfect. So, as long as you've acted in good faith and the other person gets the main thing they bargained for, a minor slip-up doesn't blow up the whole deal. So, this is where it all comes to a head.
Carl gets the house completely finished before Thanksgiving, just like he promised. But Ben looks up, sees the wrong brand of panels on the roof, and declares the entire contract broken. He refuses to pay Carl a single dime of that $200,000.
Okay, time to see how the court would likely rule. Let's tally up the final score. That verbal promise to help Ben's brother, the parole evidence rule says it doesn't count. Carl wins. The panel swap, covered by substantial performance. Carl wins again. The $25K bonus? Sorry, Carl. The pre-existing duty rule means Ben wins that one. But the final payment, that's the big one, and that goes to Carl.
So if you look at it visually, it's pretty clear. The law is overwhelmingly on Carl's side here. Yeah, Ben was right about the bonus not being enforceable, but on all the major stuff, the core of the contract, Carl did what he was supposed to do.
And because Carl substantially performed his duties, he delivered a finished house, on time, with materials of equal quality. Ben's refusal to pay up isn't just a simple disagreement, it's a total breach of his end of the bargain.
So what does that mean for Carl? It means he is entitled to what lawyers call his expectation damages. It's a fancy way of saying he gets the money he was expecting to get all along, the amount that puts him in the position he would have been in if Ben had just paid him. And in this case, that is the full original contract price, $200,000.
You know, this whole case is a perfect example of how the law tries to be both strict and fair. It respects the written word, but it also understands that the real world is messy. And it leaves us with a really fascinating question to think about. If a small flaw is okay, what kind of flaw is big enough to sink the entire ship? Where exactly does the law draw that line?